Hey everyone, welcome to ESQ Masterclass. Today's topic is about contracts. This is the first part of a series of 4 parts because there's a lot to write in a contract. When I first started my solo practice, I was hesitant to do so, really because I didn't even know what to include in the contract. And now, the first year or two, I tried to keep the contract to a minimum because I thought, why there's just so much information? Some things don't apply to a client. But now over the years, having this more experience, it's critical to have similar and the same information for every client. I practice mostly immigration law, so we have the same language mostly for every type of case. Now, if it's a removal case versus an employment or family-based, that would be different because removal has a lot more um, services that we include in the list that we could charge extra, but that'll be for a separate video that we'll have available for you. Now, each provision we have is there for a reason, really to set the expectation with your client so they can know all your different policies, for example, such as communications, how to pay you, when to pay you, and how much to pay you, and who's all involved, right? Either because we've heard of other colleagues or friends having an issue with the client on that type of provision because they didn't have it in the contract, or we've had that experience too, that where we had to learn it the hard way. Here we go. The first part is talking about who the parties are at the very top of your contract. They can include the law firm, and the other party is the applicant, your client. Now, the part where you should be more considerate about is if they have children. So in an immigration context, it's, you have to think about derivatives or a spouse. I think this is especially important in case the child gets to a point where they age out. In that sense, at least if it's a spouse as a derivative, we also have them sign the contract as well. Now, the second consideration in the contract is the scope of representation. This is a big topic that people have questions about. What is the scope of representation? You really need to fine tune the scope, because myself and other attorneys can share with you is that there could be, especially in immigration context, something can pop up. For example, we've had a case experience where, unfortunately the client didn't tell us the truth, or somehow they just forgot to tell us everything about all the names they've used, any aliases, or different date of birth. And so that's obviously important because USCIS or any government agency is going to be concerned about misrepresentation. We also write in that if there is a decision that is negative to them, a denial decision, that if they want our services for appeal or motion reconsider, motion reopen, for example, that is a separate contract because it has to be a separate fee. You don't want to include both type of services in one contract. Unless you know specifically what fee you're going to include, or if it's hourly, for example. But if it's a flat fee, sometimes we adjust the flat fee depending on the scope of the appeal, for example, what type of appeal. Another part about the scope of representation is that you should write in what type of applications you'll be preparing for your client. You shouldn't just write immigration forms to obtain benefit. So for example, if you're helping someone apply for TPS or DACA, temporary benefit, but then later on in the stage of your representation, they get married to a U.S. citizen, for example, and they somehow magically think that this contract also includes for adjustment with a U.S. citizen spouse. You and I know that's completely false. It can't be included in that contract. But just to save yourself the headache and stress, you should specifically write in what type of benefit it is. Maybe it's just a work permit, but you should write in on what basis, for example, is TPS or DACA. I've had a recent question actually today about U visas because there's a significant backlog on petitions, U visa petitions, and they're now taking, as of this year, 2020, they're taking at least probably 15 years to process until receiving the final notice of decision. And because, side note, because there's only 10,000 U visas available every fiscal year. The scope is important in this situation because you don't want to represent someone for 15 years. It just doesn't make sense business wise. Of course, you want to be available for this client throughout the from the first step to the last step. But in terms of a contract, it's important that you set the expectation that it's only your services are reserved for a certain amount of time. So, for example, something we're going to consider doing for U visas is that we represent from filing of the 918 petition, including the waiver, and all the way until they receive the provisional status. And then, because one of the concerns that attorneys have and the staff is that it's hard to get a hold of the client, especially after several years when you had no reason to contact each other. Now, granted, in our firm, our office policy is that we need to contact each client. We try to contact each client every 6 months at the very minimum, especially when there's a priority date many years down the line, just to check in with them and see if they have any questions. We want to provide value to the client. And this also gives us an opportunity if they've changed an address or changed different contact information, because by the time we find out if they changed an address, we wouldn't know until the mail bounced back, and by that time it's probably too late because we're mailing them a notice or a letter because they either don't have any email address or the reason we're trying to contact them is because we received a request for evidence, for example. So anyway, that's why it's important to have limited scope of representation. Also, another reason to have limited scope is because I could reveal or disclose at an interview that he or she had left the United States, even though throughout all your correspondence or communication with this client, they said they've never left because we've asked them, right? And somehow at the interview, they revealed that they were sent back to their country, native birth country, and that'll be a surprise for us, right? So we don't want to include situations where there's inadmissibilities, such as that requires a waiver. And so, of course, for example, if it's adjustment of status, we will write in, the only the only inadmissibility is unlawful presence, but it doesn't cover any other inadmissibility because that would, if applicable, it would require a waiver if they're eligible for a waiver. Because of course, working on a waiver, it consumes many hours of not only your time but your team's time corresponding with your client. Another critical part is putting a provision that you do not guarantee any result. I've heard of a lot of people, that come into our office and say, well, so-and-so said that they can do this. Fortunately, we haven't had that type of consultation or consultee lately, because we just don't want to have that type of client, honestly. That's not our ideal client who already comes in either price shopping or has a certain high expectation that the decision will be approved quickly by USCIS, for example. Because it's been so backlogged recently, past couple of years, that no one's had that thought. But you also don't want to guarantee any type of outcome, especially in this administration, President number 45. Also, we have a provision where we can reassign the work to another attorney. So if we have a contract attorney or of counsel, and even if we have an intern to help out with some of the data entry, because in our system, it would show who's working on the case. So if that person is speaking to the client about the case, we don't want the client thinking, well, why is this person involved in my case? Why isn't John Ting always involved in my case, or also doing the communication with me? Which I think is, it depends on your firm, right? Maybe the attorney does want to do all the communication and do all the work with the client. We don't recommend that. We recommend to have different delegation and different workflows for each specific team member, but to each their own. What we recommend is having that clause so there's no problems in the future. Notwithstanding that, we do write in that you as a principal attorney still reviews every case, at least have some kind of supervisorial review of the case and the application before it gets sent out, of course. So another provision we have in the contract is talking about who we're filing the application to, which agencies we're dealing with within immigration. So for example, USCIS, Department of Labor, or Board of Immigration Appeals, or even if it's a removal proceeding, EOIR. We want to be very specific because, for example, if it's a case that you're representing with USCIS and then this client gets caught up with a DWI and then just gets transferred to ICE custody, of course, they're going to get referred to EOIR with the notice to appear. And so we don't want clients to think that this contract, just because you're an immigration attorney, also includes services for representing them in removal proceedings, even though they have a petition filed through USCIS. So that's why it's very important, at least for us, to specifically write in which agency that we're dealing with. Even though in the scope of representation, it says, filing petition, as opposed to filing a specific application for relief with EOIR. We just don't want a client to get to have a different expectation, essentially. Along with the no guarantee provision, we also mentioned that we cannot guarantee how long the case will take. This is even during the President Obama's administration. Some cases took forever. For example, the 751 removal conditions, it is still taking forever. I had one unicorn situation where the 751 took only about 6 months, but I've never had that happen in my almost 10 years of experience. The issue with the processing time is something that no client may necessarily understand. We do our best to explain the inquiry guideline or the timing of when we can file an inquiry to USCIS, for example. And so that's why it's important that we put in the contract that we cannot guarantee how long it takes for receiving a final decision, because new policies can come up with during any administration that can potentially affect your case, or if your case is being transferred to a different national office because they're reallocating the workload. Who knows how that can affect your case? We don't know what the internal controls of USCIS. That's why we highly recommend that you write in that you cannot guarantee the timing of the case, because most of us think to definitely put that you cannot guarantee the outcome of the case, but you should do that for the timing of processing as well. In addition to sharing with the client in the contract that we do not guarantee the outcome of the case, we also write in that we cannot guarantee that ICE will not try to pick them up. We don't want a client thinking, well, just because they filed the application to USCIS that they're safe from ICE trying to detain them or arrest them. We don't know what they're going to do in the future. Maybe they get a DWI or they've committed some type of abuse, and then that's the reason ICE will show up to the house. We just can't predict the future. So that's why, like I said before, we fine tune which agency we're representing this client with. So this would definitely not include ICE. We write in that even if they're here unlawful presence, that we cannot guarantee that ICE will not show up to the doorsteps, that they're always subject to removal. We also write in this first section on the scope and nature of representation is that we require the client's cooperation. And in the fourth part of this series, We'll talk about all the different reasons why we can withdraw from the case, which the cooperation is one of them. Well, we hope you gain value this first part in the 4-part series on what to include in the contract. Please stay tuned. If you like the content, please subscribe below and hit the like button and the bell. And please, if you have any questions, comment below. We'd like to hear how we can help you.